Global expansion. Labor market recruiting choices. As business becomes increasingly global, American companies find themselves employing all or part of their workforce in positions overseas. Below are some descriptions of home host countries and what those descriptions entail. So, a home country would be where the headquarters are located, and employees who originate from the home country are called parent country nationals or expatriates. The host country is the country where the corporation will operate or is planning to operate, and employees originating from a host country are called host country nationals. Employees from other country other than the home or host are known as third country nationals. Some advantages of choosing a host country staffing strategy include not needing to acclimate an employee to language or culture. It's a reduction in hiring costs, no need to pay for a United States employee for a relocation package, no required work permits for employees already residing in the host country. Employees are familiar with the local government and environment, and employees will likely already have established connections which can assist in growing the business. Work visa requirements for Mexico. You will need a work visa to work in Mexico. The employer must assist a United States employee with obtaining a work visa for Mexico by applying on their behalf. The application, once it's approved, is passed on to a local Mexican consulate, and there are requirements for the employee. The employee will have to visit the consulate in person and present documents. They can receive an entry visa, which can be switched for a temporary residence card. And temporary residence cards are usually issued for a year at a time and can be renewed. The employee can exchange the temporary residence card to a permanent residence card should they choose to do so after 5 years. You'll see a list of valid documents needed for the process here below. Work visa requirements for Ireland. So the Irish Naturalization and Immigration Service states that if a person is from the United States and will be working in Ireland for more than 3 months, they don't need a visa, but they do need permission to stay for work and must also register with immigration. So they'll need to apply for permission to work. They'll need to have a job offer or employment contract to apply. Permission is only granted for work that is highly skilled or where there is a skill shortage in Ireland. They must have a valid passport, the employment contract, and proof of valid reason for entering Ireland upon arriving at the border. After entering the country, the employee must apply for permission to stay and register with immigration. Benefits, separations, and compensation laws for Mexico. So Mexico has a lot of the same types of compensation, benefits, and separation laws as the United States does. They have a minimum wage standard. But additionally, they also have a professional minimum wage standard. Mexico has a different requirement for what classifies as a work day or a work week and a work shift, and so those are listed out here below. They do offer vacation time and public holidays. You'll have to watch the public holidays as they're a bit different from those in the United States. They do offer paid maternity leave and some paid paternity leave. In Mexico, much as in the United States, there's no obligation under the law for employers or employees to notify the other party in advance of dismissal or resignation. In the United States, we do notify employees if we can in advance of impending layoffs. Employees hired for indefinite terms who are dismissed without a just cause are able to claim reinstatement or the payment of mandatory severance. Mexican employment legislation is subject to the job security principle, and as a result, all employees are granted protection from dismissal so that an employer can only terminate the employment relationship with an employee where the employee commits any of the specific wrongdoings as provided for in the FLL. In the United States, we have at-will employment, which means that it basically states we can terminate employment for any reason at any time. However, with EEOC governing a lot of what we do in human resources, we do have to have a valid business reason for terminating an employee. Otherwise, the employee may have protections under the EEOC. Benefits, separations, and compensation laws in Ireland. So in Ireland, the employment relationship between employer and employee is principally governed by contract law. Parties are free to choose the terms and conditions applicable to their specific working relationship. Once legally working in Ireland, migrant workers have the same minimum statutory employment protections as their Irish counterparts. Ireland does have a national minimum wage for most experienced adult employees. They also have a national minimum wage for employees who are in their first year of employment, and for employees who are under the age of 18. Benefits, separations and compensation laws continued for Ireland. So Ireland does have some maximum weekly average working hours and hours during the day that an employee can work. So you'll need to watch for that. And special conditions do apply to nighttime workers, so you'll need to be careful of that as well. Holiday pay is earned against time worked, and there are 9 public holidays in Ireland. Illness injury, there is no obligation for employers to pay employee sick pay, and there is no statutory entitlement for employee sick leave or unpaid leave, such as a career break or study leave in Ireland. Maternity and paternity protections exist in Ireland as well. Separations, the contract of employment must contain an agreed notice period. In the absence of a contractual notice period, an employer must give reasonable notice prior to the termination of an employee's contract. So that's a bit different there. The minimum notice and terms of employment acts are listed out below here. So lastly, do any of the job descriptions and job requirements need to change based on hiring local talent? Well, of course, I would think that there would be a few items to consider here. Both Ireland and Mexico do have similar types of education systems as the United States, with both countries having primary, secondary, and third level education, as well as furthering education opportunities. There may be a difference in how the universities teach and what they require of their upper level professional bachelor's degrees and requirements for, say, accountants or executives. And so you'll want to watch and have somebody do the research for what types of things are taught in those countries versus what types of things are taught in the United States, and make adjustments as necessary. If a job description requires someone to speak English, the job description might need to be changed to support the local languages or customs, or might need to state that, regardless of where you're hiring, that person still needs to be able to speak English. Considerations will obviously need to be made for work week length, hours, and monetary compensation based on the host country laws, as you saw in prior slides. There may need to be additional items to consider if employees will be expected to understand international shipping laws, etc., say for the shipping receiving position. And employees will need to be trained in cross-cultural relationships. If you have a business in the United States and part of your business is in Ireland or Mexico, these employees will need to understand how to navigate relationships between the two countries to make sure that the business is successful. I think I'll end with the statement that you will want a highly trained human resource individual to assist with navigating international hiring and law. Thank you for listening to my presentation.